In this lecture, we shall discuss the commencement of civil proceedings in Ghana. The commencement of civil proceedings in Ghana. And we shall have this discussion within the context of the civil procedure rules in Ghana. Now, how do we commence a civil action in Ghana? How do we commence a civil action in Ghana? The starting point is to read Order 2, Rule 2 of the High Court Civil Procedure Rules 2004 CI 47. Order 2, Rule 2 of the High Court Civil Procedure Rules 2004 CI 47. And it reads as follows. Subject to any existing enactment to the contrary, all civil proceedings shall be commenced by filing a writ of summons. Subject to any existing enactment to the contrary, all civil proceedings shall be commenced by filing a writ of summons. Now, the focus of this particular rule is the expression subject to any existing enactment to the contrary. It means that even though we are being told that all civil proceedings shall be commenced by filing the writ of summons, to the extent that we have the expression subject to any existing enactment to the contrary, it means that there are other modes of commencing a civil action apart from the writ of summons. And that is why we have the expression subject to any existing enactment to the contrary. Again, Order 2, Rule 1 says that subject to any existing enactment to the contrary, the party who commences civil proceedings shall be described as plaintiff and the opposing party shall be described as defendant. The party who commences a civil proceedings shall be described as plaintiff and the opposing party shall be described as defendant. It means that even though we are being told that the party who commences a civil proceedings shall be described as plaintiff and the opposing party shall be defendant, this in itself is subject to any existing enactment to the contrary. It means that there are some cases whereby a person may commence a civil action, but that person will not be described as a plaintiff. That person will rather be described as, for example, an applicant or a petitioner. So that is the import of Order 2, Rule 2. It makes us realize that even though we are being told that all civil proceedings shall be commenced by filing a writ of summons, there are other modes of commencing a civil action. So what are the other modes of commencing a civil action? The other modes of commencing a civil action are writs of summons, we have a petition, and we have an originating notice of motion, which in some books you see that it has been referred to as an originating motion or notice. So these are the three modes of commencing a civil action. And in a short while, we'll look at the circumstances under which you can commence an action with a writ of summons. We'll look at the instances under which you may commence an action by petition. And you may look at the instances that you can commence an action by an originating notice of motion. An originating notice of motion. Originating notice of motion. Originating notice of motion. So three modes of commencing a civil action. Either you have the writ of summons, you have a petition, or you have an originating notice of motion. Now, beyond this point, the next thing we must be very interested in is that if we have been told that there are 3 different modes of commencing a civil action, and that you can commence an action by a writ of summons, by a petition, or by an originating notice of motion, what is the consequence of commencing a civil action with the wrong means? If you are required to commence a civil action with a petition, and you end up commencing the civil action with a writ of summons, or you are required to commence a civil action with an originating notice of motion, and you rather went to commence the action with a writ of summons, what will be the effects of commencing the action with the wrong means? Is it going to be a mere irregularity that is going to be cured by Order 81 of the CI 47? Or is going to be a defect which will be fundamental and it will go to the very root of the matter, such that the moment you commence the action with the wrong means, it deprives the court of jurisdiction so that the court cannot even hear the matter at all? What do you think? That you are required to commence a civil action with, for example, a petition, but you rather went ahead to commence the civil action with a writ of summons? Will it be a mere irregularity that will be cured by Order 81 of the CI 47? Or it will be deemed to be a defect which will be fundamental and will go to the jurisdiction of the courts? For the answer to this question, I invite you to take a look at the book titled Civil Litigation in Ghana, in the High Court of Ghana, Civil Litigation in the High Court of Ghana, published by Robert Smith Law Group, Bobby Banson, Esquire, lead author. Specifically at page 70. This is how the learned author answers this particular question. This is how the learned author answers this particular question. That often the choice between a writ of summons, originating notice of motion, or a petition depends on the nature of the grievance and the provision of the law on how to invoke the court's jurisdiction. Often, the choice between a writ of summons, originating motion or notice, or a petition depends on the nature of the grievance and the provision of the law on how to invoke the court's jurisdiction. Where a statute has prescribed a means of commencing action under the statute, it is only that means that an action ought to be commenced. It is only that means that an action ought to be commenced. It is only by that means that an action ought to be commenced. And then also, I invite you to look at the case of Ahinakwa II. Ahinakwa II. Ahinakwa is spelled Ahinakwa. Ahinakwa. Ahinakwa II. Substituted by Ayikain Okainja III. Ayikain is spelled Ayikai. Ayikai. Okainja, Okidja. So Ahinakwa II, substituted by Ayikain Okainja III and others, reported in 2011, one Supreme Court of Ghana law reports at page 205. This is what Badegbe GSC, this is what he noted in this case. And I quote, where the rules of courts prescribe a particular mode of seeking relief, the failure to initiate the proceedings for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Again, where the rules of courts prescribe a particular mode of seeking a relief, the failure to initiate the proceedings for relief in accordance with the prescribed mode, it is not only an irregularity, but it raises an issue that goes to jurisdiction. What this in essence means is that, and to end of quote over there. So what this means is that if you are required to commence an action by a writ of summons, as required by the rules of courts, and you end up commencing the action with a petition, then the consequence is that the court's jurisdiction would not have been properly invoked, and your whole suit can be struck out for want of jurisdiction. It means that as a lawyer, if you are required to commence an action through one of the three means, and you don't go by the law, instead of commencing the action by a petition, you go by a writ. The case of Ahinakwa II, substituted by Ayikhain Okaija III and others. Ahinakwa II, substituted by Ayikhain Okaija III and others. Reported in 2011, One Supreme Court of Ghana Law Report at page 205. We have been told that where the rules of court prescribe a particular mode of seeking relief, the failure to initiate the proceedings for relief in accordance with the prescribed mode, it is not only an irregularity, but raises an issue that goes to jurisdiction. So if you commence the action through the wrong means, the court will find that you have not even properly invoked their jurisdiction, in which case the whole action can be struck out for want of jurisdiction. Now, what if a statute has provided for a remedy, but the statute has not provided the means of commencing the action? What if the statute has provided for a remedy, but that statute has not provided the means of commencing the action? And how would the person then have to invoke the court's jurisdiction in that circumstance? If a statute has provided for a remedy, but the statute has not provided for the means of commencing the action, how would the court determine how the action is going to be commenced? Now, for the answer to this question, I will invite you to look at the decision of the High Court in the case of Fidelity Bank Ghana Limited versus Gideon Ayeku. I will share the case with you shortly. So this is the case we are referring to. Fidelity Bank Ghana Limited versus Gideon Ayeku. And so over here, this is the decision of His Lordship Justice Francis Obiri. His Lordship Justice Francis Obiri. And then let's see what the learned justice says in this particular case. Now, he refers to section 33 of Act 773. Section 33 of Act 773. Act 773 is the Borrowers and Lenders Act of 2008, Act 773. This one has been, the legislation has been repealed now, but it was under this legislation that this case was decided. Now, this is what the learned justice says, and I'm reading from this particular portion that has been highlighted. Section 33 of Act 773 provides as follows. Where a borrower fails to pay an amount secured by a charge under this act, the lender may A, sue the borrower on any covenant to perform under the credit agreement, or B, realize the security charged on notice to the person in possession of the property. The use of the preposition or between section 33A and B of Act 773 gives the lender two disjunctive reliefs as to whether the lender will issue a writ of summons against the borrower in default or take steps to realize the secured property of the borrower. Let me explain this portion before I move on. Now look at the wording of section 33. It says that where a borrower fails to pay an amount secured by a charge under this act, the lender may A, sue the borrower on any covenant to perform under the credit agreement, or B, realize the security charge or notice to the person in possession of the property. So if the borrower is in default, the lender can either sue by issuing a writ under section 33A, or he can just realize the security charge. Now you can see that under section 33B, for the realization of the security charge, we have not been told how to even invoke the court's jurisdiction. The court has given you the remedy. That's two remedies. You can either sue or you can realize. But the A is quite specific. If it says you can sue, it means you can issue a writ. But if it says you may realize the security charge on notice to the person in possession of the property, it means the law has given you the remedy, but hasn't showed you how you can invoke the court's jurisdiction. It hasn't told you that you can bring an application or whatever it is. So now let me consider reading the words of Aubrey J. as it then was. In this case of Fidelity Bank Ghana Limited versus Gideon Ayeku in 2022. I consider reading as follows. In this case, the applicant has opted for the remedy under section 33B of Act 773. Counsel for respondents made fetish of Order 2, Rule 2 of CI 47, which provides that subject to any existing enactment to the contrary, all civil proceedings shall be commenced by filing a writ of summons. However, it is Strite's law that anytime there is the use of the phrase subject to in any law or statute, it means that provision of statute is not sacrosanct, but has exceptions either in the same act or in a different act. Again, it is not every civil proceeding which is commenced by the issuance of the writ of summons. For example, petition for divorce, judicial review applications. It appears Act 773 is silent as to the procedure to invoke under section 33B. However, the law is settled that where a statute provides a remedy, but does not prescribe the means by which the remedy would be attained, a party can approach a court for such remedy by any of the known processes of approaching a court, such as by motion. Again, however, the law is settled that where a statute provides a remedy, but does not prescribe a means by which the remedy would be attained, a party can approach a court for such remedy by any of the known processes of approaching a court, such as by motion. See the case of Republic versus Central Regional House of Chiefs and others. Ex parte Jan, the 9th. Ando, interested party. Reported in 2013-2014 to Supreme Court of Ghana Law Report at page 845. I am therefore of the view that the applicant's motion has properly invoked the court's jurisdiction to determine the merits of the application. It is therefore my considered view, my considered opinion, that the respondent counsel's argument that all civil proceedings should be initiated by a writ of summons is much ado about nothing. And if it was in the religious realm, I would have described it as the height of apostasy. End of quote. Now, what is happening in this case? Remember, I have told you that there are three different modes of commencing a civil action. Three different modes of commencing a civil action. Now, even though we have three different modes of commencing a civil action, we have been told that the three modes of commencing a civil action are using a writ of summons, going by an originating notice of motion, or going by a petition. Now, I ask the question that if a statute has provided for a particular remedy, but when the statute was providing for that particular remedy, it didn't show you how the court jurisdiction can be invoked. if the statute didn't show you how the court's jurisdiction can be invoked, then you are being told that the right mode of commencing the civil action is that you can commence the action by any of the known means of approaching the court. And you can, for example, go by an originating notice of motion. So in that case of Fidelity Bank Ghana Limited versus Ayeku, what the court actually held was to the effect that to the extent that the Borrowers and Lenders Act had provided for the remedy, which is to say that you may take steps to realize the security, but it didn't show how you can invoke the court's jurisdiction. Obri J, as it then was, held that you can commence the action by any of the known means, of commencing a civil action in courts. Again, let us look at the words of Bobby Banson Esquire of Robert Smith Law Group in the book titled Civil Litigation in the High Court of Ghana, specifically at page 70. This is what the learned author also says. That where a statute has provided for a remedy, but has not provided the means of commencing the action, a party can commence the action by any of the known means. So you will notice that this is more or less a reaffirmation of what we had His Lordship Francis Obije, as it then was, in the case of Fidelity Bank Ghana Limited versus Gideon Ayeku. This is a mere reaffirmation of what the learned justice said, that where a statute has provided for a remedy, but has not provided the means of commencing the action, the party can commence the action by any of the known means. And again, we must refer to the case of Republic versus Central Regional House of Chiefs and others. Republic versus Central Regional House of Chiefs and others, ex parte Jan, the 9th, under the 10th interested party, reported in 2013, 2014, two Supreme Court of Ghana law reports at page 845. At page 845. This is what His Lordship Akamba JSC said, and I quote, "If a statute provides a remedy, but does not prescribe a means by which the remedy would be attained, a party may approach the court by any known means." So what have I been saying so far? All I've been saying so far is that there are three different modes of commencing a civil action. There are three different modes, either by writ of summons, by a petition, or by an originating notice of motion. And we have asked that if a statute provides for a remedy, but doesn't provide how the court's jurisdiction is supposed to be invoked, how do we invoke the court's jurisdiction? And you remember the case of Fidelity Bank Ghana Limited versus Gideon Ayeku, where His Lordship Francis Obije, as he then was, noted that under Section 33B of the repealed Borrowers and Lenders Act, the Act provided for a particular remedy, but it didn't provide how we should invoke the court's jurisdiction. And in that particular case, the lawyers had invoked the court's jurisdiction under Section 33B by an originating notice of motion to realize the security according to Section 33B. And then the response of the other lawyer was that the action rather ought to have been commenced by a writ, and that they didn't have to commence the action by an originating notice of motion. And Obije answered the question and told them that Section 33B provided a remedy, but it was silent on how that remedy is supposed to be obtained. And that if a statute prescribes a particular remedy, but doesn't provide how the court jurisdiction should be invoked, a party may approach the court by any known means. And therefore, in that case, since the parties invoked the court by an originating notice of motion, the court held it to be a valid means of commencing the action. So watch out. If you have any statutes that provides a remedy, but it doesn't show you how you should provide a remedy. It doesn't tell you that come by an application. It doesn't tell you that come by a writ. It just mentions the remedy without telling you how you should invoke the court's jurisdiction. In that circumstance, the case of Republic versus Central Regional House of Chiefs and others, ex parte Jan, the 9th, under the 10th interested party, reported in 2013, 2014, two Supreme Court of Ghana law reports at page 845. Akamba GFD said as follows, and I quote once again: if a statute provides a remedy but does not prescribe any means by which the remedy would be attained, a party may approach a court by any known means. So now the question that I have to ask is this. There are times when a statute would prescribe that come by an application. So for example, if you look at the Constitution, for example, and you look at Article 33, Clause 1, it clearly mentions that anybody who alleges that there is a breach or a threatened breach of his fundamental human rights, you may apply to the court for redress. And the operative word over there is apply. That you can apply to the court for redress. So this is a clear case of the Constitution providing for a particular remedy that you can apply to the High Court for redress. And it has showed you how you should invoke the court's jurisdiction, that you should come by an application. So if the statute has mentioned the remedy and has also added that you can invoke the court's jurisdiction by an application, that is when you commence the action by an originating notice of motion. That is when you commence the action by an originating notice of motion. So the next question I'm asking over here is that which categories of actions are commenced by an originating notice of motion? And please pay attention to this part very well, because we are moving on to the next mode of commencing a civil action. We know that for a writ of summons, we are told that subject to any existing enactment to the contrary, all civil proceedings shall be commenced by filing a writ of summons. We are clear about that one. We are moving on to which categories of actions can be commenced by an originating notice of motion. Now, once again, if you look at the book titled Civil Litigation in the High Court of Ghana, written by Bobby Banson Esquire of Robert Smith Law Group, and you look at page 72, this is what the learned author says, and I quote: an originating motion or notice is adopted where a statute provides for the making of an application to a court. A statute provides for the making of an application to a court, but does not make any stipulations on the manner in which the said application is to be made. Neither are there any rules of courts concerning the procedure. In other words, a statute. So I have finished the quotes. A statute has made provision that you can make an application to the court for a particular remedy. But the statute doesn't tell you how you should bring the application. It doesn't tell you how the application is supposed to be made. And there are no rules of court too concerning that procedure. You invoke the court's jurisdiction by what you call an originating motion or notice. Why do we call it an originating motion or notice? Now think about it. We are using this motion to commence an action. We are using the motion to originate an action, to commence an action right from the start. We are using the motion to commence an action right from the get-go, that you don't have any action in the court. So you are commencing the action from afresh. You are originating it. You are starting the action. So because you are using that motion to originate an action, that's why we call it an originating motion or notice, or originating notice of motion. It is because you are using this motion to commence a civil action. Somebody will wonder, why don't we just say a motion? It's be a mistake, because if you look at Order 19 or the CI 47, If you look at order 19 of the CI 47, specifically, if you advert your mind to order 19 rule 1, if you advert your mind to order 19 rule 1, take a critical look at your CI 47, look at order 19 rule 1, and look at the language over there. You will notice that under order 19 rule 1 of the CI 47, you are told that every application in pending proceedings shall be by motion. In pending proceedings. So if you look at the 19 rule 1, it says that every application in pending proceedings shall be by motion. It means that under the CI 47, there are two kinds of motions that you can talk about, at least two kinds. For example, if I commence an action in the court by writs and I'm asking for a declaration of title to land, there's a live matter pending before the court. So there's a pending matter before the court. If during that pending matter, I want to apply for something, if during that pending matter, I want to apply for something, the application that I have to make, I can make it by motion. So look at order 19 over here. Order 19 rule 1, look at the language. Every application in pending proceedings shall be by motion. It means that when you have a live matter pending before the courts, and you want to apply for an injunction, you want to apply for discoveries, you want to apply to strike out a writ of summons, because it's an application in pending proceedings, that application must be by motion. So you realize that the motion can be a motion in pending proceedings, or it can be a motion that is used to commence an action. Now, if you are going to apply for an interlocutory injunction, you remember from law of equity that before you apply for an interlocutory injunction, you must have commenced a substantive matter before the court. So there's a substantive case pending before the court. For example, you are asking that this land belongs to you. And after you've sued that this land belongs to you, you are saying that until the court finishes hearing the case, you want the court to injunct these people from developing the land. It means that while the matter is pending before the courts, you want to apply to the court for something. That application must be by motion, because it's an application in pending proceedings. This application is different from the one we have under what we call an originating notice of motion. So if you are going to use the motion in the pending proceedings, then it is a simple motion that will be supported by an affidavit. But if it's a motion you are using to commence an action, you are using to originate an action, that's the motion that we refer to as an originating notice of motion. An originating notice of motion. I ask that you take a look at Article 33 of the Constitution of Ghana. Look at the language of Article 33. Where a person alleges that a provision of this Constitution on the fundamental human rights and freedoms has been or is likely to be contravened in relation to him, then, without prejudice to any other action that is lawfully available to him, that person may apply to the High Court for redress. You may apply. It means that if you want to bring an action for the protection of your fundamental human rights, one option available to you is that you may apply. So the statute is telling you that you can apply. The Constitution, it says you may apply. But it doesn't show you how you can apply to the High Court for redress. So if somebody violates your fundamental human rights right now, you want to bring an action for the protection of your fundamental human rights, you are commencing a fresh action. And the law says that you may apply. So if you are going to apply, you can apply by an originating notice of motion, because we have been told that where a statute makes provision that you can apply to the court for a particular remedy, but it doesn't show you how you should make the application, then you can properly invoke the court's jurisdiction by an originating motion or notice, or originating notice of motion, because that motion is not a motion in pending proceedings. It's a motion you are using to originate or commence an action. Let's look at another example under Order 55 of the CI 47. Order 55 deals with application for judicial review. Now, if you look at the language of Order 55, it says that an application for, or in the nature of mandamus, prohibition, certiorari, quo warranto. If you look at all these things under Order 55, if you're applying for mandamus, prohibition, certiorari, or quo warranto, it says that it shall be made by way of an application for judicial review to the High Courts. If you want to apply for mandamus, prohibition, certiorari, or quo warranto, so if you're applying for judicial review, we are told by Order 55 that it shall be made by way of an application for judicial review to the High Court. So this is a clear case where the rules is saying that you should invoke the court's jurisdiction by an application. You are going to commence a fresh action for judicial review. And it's saying that you should commence it by an application. But the statute or the rule hasn't showed you how should you make this application. Because you are going to commence a fresh action, we say that application is what we call an originating motion or notice, or originating notice of motion. Why do we have the word originating? Because you are using it to commence a fresh action. And that is different from the Order 19 Rule 1 application. That is an application in pending proceedings. So you must see the difference. You can have a motion simpliciter, which will be a motion in pending proceedings, or you can have a motion used to commence an action. The one used to commence an action is the one we describe as originating notice of motion. Now, let us look at the book titled Civil Procedure, A Practical Approach, written by S. Kwamitete at page 429 and 430. Civil Procedure, A Practical Approach, written by S. Kwamitete at page 429 and 430. This is what the learned author says, and I quote, originating motions are authorized under enactments or the rules of courts. Where an enactment or the rules expressly authorize the making of an application to the courts or a judge, such applications shall be made by a motion. Where the enactment provides some other mode, a motion will satisfy the requirements. Originating motion, notice of motion, properly utilized, would dispose of the matter in dispute expeditiously, avoiding the cumbersome procedure for commencing actions by writ of summons. The notice of motion must be entitled in the matter of so and so, and state clearly the grounds of the application and the order or relief sought. End of quotes. What is of particular relevance for you to note over here is that, take note of what he just mentioned, that originating notice of motion properly utilized will dispose of the matter in disputes expeditiously. Expeditiously. It is therefore not surprising that when we read Article 33 Clause 1, that says that if you want to seek a remedy for a breach of your fundamental human rights, you can go by an originating notice of motion. Because strictly speaking, if you commence an action by an originating notice of motion, you only file your motion, the other person files his affidavit in the position, the court determines how it's going to determine the action. Straight away, within a short while, you get your judgment. But if you commence an action by a writ, you commence by a writ, you serve the defendant, he has to enter appearance within 8 days, then he also has some other 14 days to file his defense. Plaintiff also has 7 days to file your reply. Within 1 month, pleadings close, you now apply for directions, then court orders, filing of witness statements. Then in fact, it goes on. In fact, you can have applications for amendments, so many things that can come up. So it's not surprising that we are being told by the learned author, S. Kwamitete, that an originating notice of motion, properly utilized, would dispose of the matter in dispute expeditiously. It's therefore not surprising that when it came to fundamental human rights under Article 33, we're told that you can commence the action by an application. So that if I want a remedy of a breach of my fundamental human rights, I'm not tied to go with the cumbersome procedure of a writ of summons. I can go by an application, and that application can be by an originating notice of motion, which you have been told would ensure that the matter is disposed of expeditiously. Let us take a look at what the learned author has said in the book titled Civil Litigation in the High Court of Ghana, a very good book, Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, Bobby Banson Esquire. Read at page 72, and this is what the learned author says, and I read. Where an action is commenced by originating motion or notice, the applicant files the motion paper together with an affidavit, as well as any exhibits which the applicant intends to rely on. The respondent files an opposition together with any exhibits that he intends to rely on. Thereafter, the court determines the mode of proceeding with the case, either on the affidavit evidence or by calling additional evidence. The rules of pleadings in respect of the content of a pleading A or do not apply over here. End of quote. This is a very profound statement, and it's supposed to give you an insight as to the benefit you get if you commence an action by an originating notice of motion. Now, if you've seen a writ of summons before, nobody files a writ and attaches any evidence. Nobody files a writ and attaches any exhibits, because when you file a writ, it's your writ of summons accompanied by a statement of claim. No exhibit is attached to the writ of summons. No exhibit will be attached to a defense. When you file a writ, you must file your statement of claim, defendant files a defense, plaintiff will file a reply, then you apply for directions before the court will now order you to file your witness statement. That is where you now add your exhibits. And that may take a lot of time. But if you commence an action by an originating motion or notice, straight away, when you are commencing your action, your motion paper, your affidavit, and any exhibit you have, you can add all at once. When the respondent is also filing his opposition, he can file the opposition together with any exhibit at once. And the court can determine the whole case only on the affidavit evidence without even calling without calling additional evidence. So just your motion paper comes together with all the evidence you have. Affidavit opposition comes with all the evidence you have. Then the court looks at this too and determines the case. Very fast. That's why we are told that if you commence an action by an originating motion or notice, it allows you an expeditious means of resolving your disputes. And it's actually been contemplated by Order 19 Rule 2. Order 19 Rule 2 gives blessing for commencing an action by an originating notice of motion. This is what it says, and I quote, "Proceedings by which an application is to be made to the court or a judge of the courts under any enactment," emphasis, under any enactment. So proceedings by which an application is to be made to the court or a judge of the court under any enactment, shall be initiated by motion. So if there's an enactment there, and then the enactment provides that you can commence an action by some proceedings under that enactment, we are being told that proceedings by which an application is to be made to the court or a judge of the courts under any enactment, it shall be initiated by motion. And where an enactment provides that an application shall be made by some other means, an application by motion shall be deemed to satisfy the provision of the enactment as to the making of the application. So if anybody asks you, what is your authority for saying that you can, even an enactment makes provision that you can apply, you come by an originating notice of motion. If anybody asks your authority, refer to all the text writers are giving you, but under the CI 47 or the 19 Rule 2 gives the answer. Proceedings by which an application is to be made to the court or a judge of the court under any enactment. So if the enactment says that, like the Companies Act, it says that you can apply to the court for remedy against oppression. So how do you apply to the court for a remedy against oppression? You can come by an originating notice of motion. So What are some of the examples of actions that you can commence by an originating notice of motion? I've given you examples already. One, if you want to enforce fundamental human rights pursuant to Article 33 and Order 67 of the CI 47, you can come by an originating notice of motion. Order 67 of the CI 47 deals with enforcement of fundamental human rights. That one to say that you can come by application. Again, if you want to invoke the supervisory jurisdiction of the High Court for judicial review pursuant to Order 55 of the CI 47, that one too, remember we checked there, Order 55, that application for judicial review shall be by an application. So if you want to apply for judicial review also pursuant to Order 55, you go by an originating notice of motion. Again, if you want to apply for an order of committal, somebody has breached a court order, you want the court to convict him for contempt, an application for committal pursuant to Order 50, Rule 1, Sub Rule 2, that one too, it shall be by an application, and you shall do it by an originating notice of motion. Now, I have mentioned originating notice of motion over and over again. And I think that it is important that I let you see how the originating notice of motion looks like. How it looks like. So look at how the originating notice of motion looks like. This is what you use to commence the action before the courts. And this one, the title has been done in a way to reflect that a person has gone before the district court of Amasaman. And then that district court in Amasaman has taken a decision which the applicant wants to quash by a writ of prohibition and certiorari. So you want to quash the decision and you want to prohibit that district court from going ahead with the matter. So definitely, if you are in a district court, you know there are lower courts. And if you want to challenge what the district court is doing by judicial review, under Article 141 of the Constitution, the court that has jurisdiction, supervisory jurisdiction over the district court is the High Court, under Article 141. So if you are applying for judicial review in the nature of prohibition to restrain the court, and it's a right to quell what they have done, this is how your title will look like. So we have the Superior Court of Judicature in the High Court of Justice. We have the Accra AD, you have your suit number. Then we have, in the matter of an application for an order for judicial review, in the nature of certiorari and prohibition, pursuant to Articles 141 of the Constitution, of the 1992 Constitution, and Order 55 of the High Court Civil Procedure Rules 2004 CI 47. And in the matter of the Republic versus the District Court, Amasaman. So the person whose decision you want to quash is who? The District Court. So that's why you do it, the Republic versus the District Court, Amasaman, Accra. Then who is the one applying for the judicial review? The person applying is called Liontando. So ex parte Liontando. So Republic versus the District Court, Amasaman, ex parte Liontando, because Liontando is the one applying for the judicial review. But you see, when Liontando was in the District Court, the case was between he and Daniel Asari. So he can't come to the High Court alone to quash without Daniel Asari being aware. So Daniel Asari interested parts. So let me give you let me explain this. Let me explain this in a different way. So the District Court case will be between Liontando versus Daniel Asari. So these are the parties that were in the district courts at Amasaman. Now the High Court judge, the District Court judge has taken a decision which is breaching, let's say, natural justice, and it's affecting Liontando. So Liontando says that, my friend, District Court judge, I will not in court this day. So why did you grant this remedy against me? What you are doing is in breach of natural justice. District Court says that you can't do anything. I have given my decision. Now, Liontando feels that what the judge has done is breach of his natural justice. It is breach of his right to natural justice. So he wants to quash it. So Liontando then goes to the High Court. So when you go to the High Court, because you want to quash the decision of the district court, you borrow the name of the Republic versus the Republic versus. So the person whose decision you want to quash becomes what? The district court. Amasaman. Because you want to quash the decision of the district court. But who is the one applying to the High Court? Liontando, ex parte Liontando. But who else has an interest in the case? The Namasari interested party. So this is how the title will look like. The Republic versus the district court. So the district court is the one whose decision you want to quash. Ex parte Liontando, then the Namasari interested party. So that's how the title looks like. So the Republic versus the district court Amasaman, ex parte Liontando, the Namasari interested party. So many people think ex parte only means without notice. But in civil procedure, ex parte can also mean on the application of. In this context, the ex parte means that the Republic versus district court Amasaman. But the one applying for the judicial review is Liontando. So ex parte. So the ex parte over here means on the application of Liontando. And then who else has an interest? The Namasari interested party. That's how the title will be. Then you have a motion. Motion on notice invoking the supervisory jurisdiction of this honorable court for judicial review in the nature of prohibition and an order of certiorari, pursuant to Article 141 of the 1992 Constitution and Order 55 of the CI 47. Please take notice that this honorable court shall be moved by counsel for the applicants herein, praying for an order for judicial review by way of certiorari, to bring up to this honorable court the ruling of the district court, Amasaman Accra, dated 4th December 2004. Quorum, then you bring the name of the judge, His Worship Michael Lyon, Mr. In seals number so and so, A1/419/419, titled Liontando versus Namasari, for the purpose of having same quashed for want of jurisdiction, an error of law patent on the face of the record, and for a further order transferring the hearing of the suits to another court differently constituted, as further expressed in the supposing affidavit. Usually, if you are going to quash, we'll ask that, okay, if I'm quashing, let me move it from this person to a different person. Because I don't want to go there for the person now to say that, hey, I'm going to call whatever they've done. So sometimes lawyers will add the prohibition together with the certiorari. And for such further orders, as this honorable court may deem fit in the circumstance, what will be moved on this day and then this day. So look at the people that we are serving. We are serving who? The registrar, District Court Amasaman Accra, and we serve the interested party too. So this is how the motion paper will look like. And then you have your supporting affidavits. Your supporting affidavits that would accompany it. But I just have to show you how the motion paper looks like. How the motion paper looks like. So take a look at it very well. Take a look at it very well. All right, so this is how an originating motion or notice looks like. And remember, like I told you, this is used to commence an action. It is used to originate an action. That is why we call it an originating notice of motion. So that was a sample of an originating notice of motion. And why were we looking at this? We're looking at this because we've been told that there are three principal means of commencing a civil action: a writ of summons, a petition, and an originating notice of motion. We have dealt extensively with what an originating notice of motion is. And then I have to show you a sample. Now let's come to a petition. What actions can we commence by a petition? What actions are commenced by a petition? There are a number of them. And I know the notorious one that many of people are aware of is divorce. That divorce, you can bring an action by a petition. So let's look at them. 1, matrimonial causes as provided for under Order 65 of CI 47 and Section 1, Subsection 1 of the Matrimonial Causes Act of 1971, Act 367. Whenever I mention these things, I expect that you open them, read them, and see what's over there. It's not enough for you to know that, oh, for divorce, you come by a petition. You must show the order in the CI 47 that deals with divorce petitions. So that's why I've given you matrimonial causes as provided for under Order 65. So open Order 65 and see what is over there about commencing matrimonial causes by a petition. And also open section 11 of the Matrimonial Causes Act and see why I'm making reference to it. In this context, matrimonial causes include the following: proceedings for divorce, nullity, presumption of death, dissolution of marriage, maintenance orders, and child custody. All these ones, you commence them by a petition. So it's not only divorce. That's why I prefer to use matrimonial causes, because divorce comes under the matrimonial causes. It can be proceedings for divorce, nullity, presumption of death, dissolution of marriage, maintenance orders, and child custody. Please do not move ahead from this point unless you have opened Order 65 of CI 47 and read it for yourself, and you've seen what is over there. Like I'm as we have said, it is not enough for you to merely state that under order that a divorce proceeding can be commenced by a petition. No, you must actually go to the extent of showing us the order that allows you to commence a divorce action through a petition. That is the only way that we can say that, yes, you are making significant progress. So that is how to commence actions by a petition. Like I'm saying, it's not enough for you to just merely state that divorce matters is by a petition. No, you must show us the order dealing with it, Order 65 of CI 47. Another action you can commence by a petition are parliamentary election petitions in the High Court, pursuant to Article 99 of the Constitution, as well as Section 16 and 17 of the Representation of the People Law, 1992, PNS Law 284. Once again, it's not enough for you to just say that, oh, parliamentary election petitions, you can go by petition. No. Show us that it is by petition because of Article 99 and also Section 16 and 17 of the Representation of the People Law, 1992, PNS Law 284. Again, if it's also a presidential election petition, under Article 64 of the Constitution, that one also you go by a petition. And also, if you want to wind up a company or liquidate a company under the provisions of the Corporate Insolvency and Restructuring Acts of 2020, Act 1015, and the Companies Act of 2020, Act 992. That one too, you go by a petition. So at least from this, you have at least 4 modes or 4 actions you can commence by a petition. Matrimonial causes, and like I've said, remember, is under Order 65 of the CI 47. Parliamentary election petitions, Article 99 and Section 16 and 17 of the Representation of the People Law of 1992, PNS Law 284. Then we have presidential election petitions in the Supreme Court under Article 64 of the 1992 Constitution of Ghana. And then we also have the winding up of a company or liquidation under the provisions of the Corporate Insolvency and Restructuring Act of 2020 and the Companies Act of 2020. These ones are different modes of commencing actions by a petition. So if we ask you, what are the modes, what kind of actions can you commence with a petition? You shouldn't just mention matrimonial causes. No. Mention the matter and refer to the order that it deals with it. Then we know that we are speaking the right provisions. So now we are done with 2 different modes of commencing a civil action. In fact, remember, I gave you 3 types. three ways of commencing a civil action: by writ of summons, by petition, and by an originating notice of motion. I have showed you that under Order 2, we are told that subject to any existing enactment to the contrary, all civil proceedings shall be commenced by filing a writ of summons. Remember that one. Remember also that we dealt with an originating notice of motion, which says that if you want to commence an action before a court, and there's a statute saying that you shall apply to the court for a remedy, but the statute didn't specify how you should make the application, you can invoke the court's jurisdiction by an originating notice of motion. Remember again that we said that another way of commencing a civil action is by a petition. And you've seen how the petition can be used to commence an action. And you've seen the different matters that we can commence by a petition. Now, let us look at the writ of summons itself. That what actions are thereby commenced by a writ of summons? According to Order 202, unless there's any enactment that has any made provision, then every civil proceeding is supposed to be commenced by a writ of summons. So the general position is that every action will be commenced by a writ of summons, unless you have an enactment that has made a provision to the contrary. So if there's no enactment that has made any provision to the contrary, then you commence the action by a writ of summons, according to Order 202. What is a writ of summons? What is a writ of summons? We've mentioned it a lot in this lecture. Let us see what a writ of summons is. What is a writ of summons? And I'm going to refer to a definition given by S. Kwame Tete in his book, Civil Procedure, A Practical Approach. And I'm going to read from page 183. 183. What is a writ of summons? And I'm quoting. Under CI 47, a writ of summons is a single, composite, all-purpose form for the commencement of civil proceedings. It bears the coat of arms. The person initiating the action must complete the form and file it in the registry. Must complete the form and file it in the registry of the venue, i.e., the High Court or Circuit Court in which it is proposed to commence the action. When filed, it is issued by the registrar of the court in the name of the Chief Justice, the head of the judiciary. It is served in order to inform the defendant of the nature of the claim, the identity and address of the plaintiff, and the venue. The writ of summons initiates the action. And again, as Kwame Tete Civil Procedure, A Practical Approach at page 185 says as follows. The writ of summons informs the defendant that the plaintiff has instituted an action in the language of command and majesty. The writ orders the defendant to enter appearance within 8 days, inclusive of the day of service of the writ on the defendant, failing which the court may proceed to give judgment without further notice to the defendant. So this is what we mean by a writ of summons. The moment a writ of summons is a command of the Republic of Ghana, and the person who seals it is the Chief Justice, the person who will seals it to be the registrar. But in the name of the Republic, the Chief Justice is summoning you. Come and appear here within 8 days. If you don't come, so if you don't come, we shall proceed to give judgment in your absence. So that is the writ of summons. Remember, it is sealed by the registrar. By unsealing it, you put the stamp of the Chief Justice over there. So the moment you are served with the writ, it means that the Chief Justice is commanding you in the name of the Republic of Ghana that you must enter appearance. And that's why if you don't enter appearance, we can proceed to give judgment without further notice to you. Now, what are the contents of the writ of summons? You will see these. They've been listed under Order 2 of the CI 47. So content of the writ of summons. Order 2, you see that you must have the residential and occupational address of the plaintiff. It must have the residential and occupational address of the defendant. It must have the endorsement of the relief sought by the plaintiff. So if you are the plaintiff, what reliefs are you seeking from the court? Those ones must also be on the writ of summons. Then in the event that the plaintiff is used by a lawyer, then again, the writ of summons must definitely have the occupational address of the lawyer. And if the plaintiff sues in the representative capacity, then the writ must disclose the capacity in which the plaintiff sues. So these are generally the contents of the writ of summons. And if you look at Order 206, it says that every writ shall be filed together with a statement of claim as provided for in Order 11. And no writ shall be issued unless a statement of claim is filed with it. Every writ shall be filed together with a statement of claim as provided for in Order 11. And no writ shall be issued unless a statement of claim is filed with it. This statement is very important. And because of its crucial nature, I would have to, at this point, refer to some, demonstrate to you from a sample of a writ of summons. So let's look at a sample of a writ of summons so that we see what we mean by saying that the writ of summons must be accompanied by a statement of claim. So now let's take a look at this. You will see that the writ has at the top the Republic of Ghana. It has the coat of arms. You will see that it's showing the court in which you are issuing the writ at. You will see that it has the names of the parties here, first plaintiff and his address. It has the name of the second plaintiff also with his address. It has the name of the first defendant with his address. It has the name of the second defendant too with the address. And look at the wording of the writ. An action having been commenced against you by the issue of this writ, by the above named plaintiff, you are hereby commanded that within 8 days after service of this writ on you, inclusive of the day of service, you do cause an appearance to be entered for you. And take notice that in your default of your so doing, judgment may be given in your absence without further notice to you. So when the registrar would date this, then when he seals it, the registrar seals it, then you put the stamp of the Chief Justice there. It means that now it has been sealed. The Chief Justice, now they've given life to it. So now when it is served on you, you have to be entered, you have to enter appearance. So that's how the writ of summons looks like. Take a critical look at it. It has a front and a back. So the front and the back. So the front is what you're seeing on the left, and the back is what you're seeing on the right. So the back has a heading, statement of claim. And over there, what you put over there will be the reliefs. This is what we usually call the endorsement of the reliefs. So at the back of the writ, you will see recovery of the sum of 7.5 million Ghana cedis, being the principal and accrued interest on the loan facilities that were granted to the defendants, but which they have failed to pay. The second relief, interest on the sum of 7.5 million at the contractual rate of 12.5% from 4 June 2020 to date of final payment. Then relief number 3, damages for breach of contracts. Then relief number 4, costs. Then the rate also who issued this, the name of the lawyer will be there. Remember I mentioned that if it is issued by a lawyer, then the occupational address of the lawyer must be there. So Michael Lyon Mensah Esquire. Then his address is as follows: Lyon and Associates, plot number 419, 2nd Manco Street, East Legon, Accra. Then the lawyer's license number 2 must be there. EGAR, this is what you have over here. So this is the lawyer's license number. I'm making that one in red. His address, Let me make that one blue. Yes, so you can see the difference. You must have the name of the lawyer there, and let me make this will be the endorsement. Let me make the endorsement. Let me highlight that one in green. Green may not be too clear. So let me still make that one red. So this is the endorsement. So endorsement is the first one in red. Plaintiff claims against the defendant as follows. So this is the endorsement of the reliefs. Then we have the name of the lawyer. We have his address. We have his license number. That's the back. This is what will be at the back of the writ of summons. And the front of the writ of summons, you have the names of the parties, their address, and all of that. So if you remember, when I was mentioning the content of the writ of summons, I mentioned that the writ of summons must have the residential and occupational address of the plaintiff. You can see it over there. You see the address of the plaintiff is over there. Then we have the address of the defendant as well. You see it also over there. Then we also have endorsement of the relief sought by the plaintiff. So that's what you have at the back. This is the second page over here. These are what you have over here. Then you also have, in the events that the lawyer sues by a lawyer, I mentioned that he must have the occupational address of the lawyer. So you see, which was issued by the lawyer over here and the address over here. Then you have the lawyer's license number. So this is a sample of a writ of summons. Let me quickly add that there are times when, for example, you want to look for the address of the defendant and you don't know where exactly that he lives. So look at the CI 47 order 205 sub rule 5. Order 205 sub rule 5. Look at what it says. Where the address of the defendant after diligent search is not known, the plaintiff shall indicate on the writ that the plaintiff shall direct service. You can see it over here. Order 205 sub rule 5. Where the address of the defendant after diligent search is not known, the plaintiff shall indicate on the writ that the plaintiff shall direct service. So, if you see over here, order 205 sub rule 5, it says that where the address of the defendant after diligent search is not known, the plaintiff shall indicate on the writ that the plaintiff shall direct service. So what does that mean? It means that for this writ of summons, for example, as you can see on the screen, if I can't find the address of Mr. Tando and I write Accra, I can put over here into bracket plaintiff shall direct service. Meaning the plaintiff will go with the bailiff and tell the bailiff that this is Mr. Hans Tando to serve him with the writs. So you see the front page over here. If you, after diligence search, you can't find it, you must indicate over there that plaintiff must direct service. You can't leave it absent. You can't leave it blank. So this is what we mean by saying that these are some of the content of the writ of summons. The parties will be here, the address will be here, you have the coat of arms, and then you have the command in the back, the endorsements. You have the reliefs here, you have the lawyer issuing the writs, you have his occupational address, you have his license number, and they must all be there. Now, these reliefs, this statement of claim you see at the back here, at the back of the writ of summons, it is not a pleading. It is just for you to state your reliefs. But when you come to the statement of claim itself, so the statement of claim will have the same names of the parties, first plaintiff, second defendant, first defendant. So let's say this is your statement of claim. Paragraph 1, 2, 3, 4, 5, 6, up to 9. Usually the last paragraph in the statement of claim, you will see the lawyer saying that you repeat the reliefs that you have mentioned in the writ of summons. So you realize on the writ of summons, we had the reliefs here. Recovery of the sum of 7.5 million, interest on this amount. So those same things will be on the statement of claim. Some lawyers will just make, for this particular portion, they will rather make it, for example, like this. You might just say, wherefore the plaintiff has suffered damage and claims jointly and severally against the defendants, the reliefs endorsed on the writ of summons. Full stop. So the moment they put it there this way, then it means that the reliefs they are claiming are the reliefs that have already been stated on the writ of summons. But many a time you see lawyers too that will be what? Repeating it. So if you remember, on the rates, behind the rate, this one, we had these release over here, recovery of the sum of 7.5 million, interest on this amount, damages. This same release, when you come to the statement of claim, after you've dealt with all your paragraphs, the final paragraph is usually the statement also of the release. So you also endorse the release also on the statement of claim. But the question is that what if I'm stating my release, and let's say over here, I have asked for recovery of sum, but I don't ask for the interest, the second relief. So let's say that I have all of these on the writ of summons, but on the statement of claim, in the statement of claim, when I came here, I didn't add this interest. So this one is missing from there. Would the fact that I have mentioned it on the writ of summons, would it cure that I haven't mentioned it in the statement of claim? This is a very important thing, so pay attention. I'm saying that if you look at the writ of summons, this writ, this is the front page, this is the back page. The back page has the reliefs. Back page has the reliefs. Back page has the reliefs. Correct. Now these reliefs are 1, 2, 3, 4. Assuming in my statement of claim, which is the pleading, I don't mention this relief, the interest. What will be the implication of it? Now let us go back and then to order 2 and see what we will see over there. So you will notice that under order 206, we are told that every writ shall be filed together with the statement of claim as provided for in order 11. And no writ shall be issued unless a statement of claim is filed with it. It means that the writ of summons, the one that has the coat of arms, it must come together with the statement of claim itself, the pleading, where you have paragraph 1, paragraph 2, paragraph 3, where you tell your story that you have before the court. Every writ must be issued, and if it is being issued, you must be sure that the writ is being accompanied by a statement of claim. If it's not accompanied by it, it's a problem. Look at order 11 rule 1 of CI 47. It says that the plaintiff shall serve a statement of claim on its defendant at the same time as the writ or notice of the writ is served on the defendant. At the same time that the writ or its notice is being served on the defendant, make sure you also serve a statement of claim. And the statement of claim I'm talking about is the one contemplated by order 11. That one is a pleading. That's where you give your facts, your story that you have before the court. The plaintiff is a carpenter, defendant is a farmer. Sometime in 2020, defendant did this to plaintiff. And that's why I'm asking for these reliefs. Every writ, it shall be filed together with a statement of claim. And it's not supposed to be issued unless the statement of claim is filed with it. Now look at the 11 rule 1, sub rule 2. It says that when the plaintiff fails to serve a statement of claim on the defendant, that defendant may apply to the court for an order to dismiss the action. And the court may by order dismiss the action or make such other order on such terms as is considered just. So it is not for fun that order 206 is saying that every writ shall be filed together with a statement of claim. When you are filing the writ, make sure that the writ is always accompanied by a statement of claim. And sometimes you'll be confronted with some questions. That what are some of the factors that may render a writ of summons defective? One defect will be when the writ of summons is being issued and there's no statement of claim accompanying it. Because we've been told that if it doesn't accompany it, you can bring an action for the whole, you can bring an application for the whole suit to be dismissed. We have seen a sample of a writ of summons already. You remember I asked the question that what is the legal effect of the plaintiff stating some reliefs on the writ of summons? So on your writ of summons, you have about 5 reliefs. But when you came to your statement of claim, your last paragraph, where you state your reliefs at, you don't mention 2 of them. And then my question was, would the fact that you have mentioned them on the writ of summons, would it still be applicable? Will we still rely on those reliefs? Let us see what the learned author says. The question is, what is the legal effects of a plaintiff stating some reliefs on the writ of summons which are not stated in the statement of claim. And I'm reading from the book titled Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, Bobby Banson Esquire. Like I said, this is a very good book, and it's one of the most recent books on civil procedure in Ghana. This is what the learned author says at page 74, and I quote: "The writ of summons must be endorsed with a statement of the nature of the claim, relief or remedy sought in the action. It must be noted that the reliefs endorsed in the statement of claim take precedence over the reliefs endorsed on the writ of summons, so that where there is a relief which is endorsed on the writ of summons, but was not repeated in the statement of claim, that relief shall be deemed to have been abandoned by the plaintiff. The writ of summons must be endorsed with a statement of the nature of the claim, the relief or remedy sought in the action. It must be noted that the reliefs endorsed in the statement of claim, they take precedence over the relief endorsed on the writ of summons. So that where there is a relief which is endorsed on the writ of summons, but was not repeated in the statement of claim, that relief shall be deemed to have been abandoned by the plaintiff. Let us look at this case of Unilever Ghana Limited versus Kama Health Services. Unilever is spelled Unilever, Unilever Ghana Limited versus Kama, K-A-M-A, Kama Health Services Limited. Reported in 2013-2014, 2 Supreme Court of Ghana law report at page 884. This is what the court said, and I quote: "The reliefs which are stated in the statement of claim, on which facts have been pleaded, will supersede the endorsement on the writ. The statement of claim gives the particulars of the relief sought and states the grounds upon which the plaintiff is before the court. That enables the defendant to plead, and any objection is to be raised by the defendant at this point, or he'll be deemed to have waived it. A case is contested on the basis of the pleadings. Hence, the relief endorsed on the writ, which was varied in the statement of claim, will stand as amended to the extent of the variation." I'll take that portion again. A case is contested on the basis of the pleadings. Hence, the reliefs endorsed on the writs, which was varied in the statement of claim, will stand as amended to the extent of the variation. This is distinguishable from the situation where a relief endorsed on the writs is not repeated in the statement of claim, in which the party is deemed to have elected to abandon that relief. Again, look at the case of Entry and Amponsa. Entry and Amponsa, reported in 1964 Ghana law report at page 531, per he from Benjamin. This is what the justice said, and I quote: "Where a claim contained in the writ of summons is not repeated in the statement of claim, then the plaintiff is deemed to have elected to abandon the claim." So look at these two cases: Unilever Ghana Limited versus Kama Health Services. Unilever Ghana Limited versus Kama Health Services, reported in 2013-2014, 2 Supreme Court of Ghana law reports. We're told that the relief endorsed on the writs, which was varied in the statement of claim, will be deemed as amended to the extent of the variation. And in Entry and Amponsa, we are told that where a claim is contained in the writ of summons and it is not repeated in the statement of claim, then the plaintiff will be deemed to have elected to abandon that particular claim. Bear in mind that under Order 11 Rule 15.1 of the CI 47, Order 11 Rule 15.1 of the CI 47, it says that a statement of claim shall state specifically the relief or the remedy which the plaintiff claims, but cause need not be specifically pleaded. A statement of claim must specifically state the relief or the remedy which the plaintiff claims. So the question I pose, now let's look at this statement of claim. This writ of summons, this is the front page And this is the back page. The back page has release 1, 2, 3, 4. Let me add over here, for example, let me make as relief let me have as release IV special damages. In the sum of, let me make this 500,000. See this from the defendants. So these are 5 releases over here. 1, 2, 3, 4, 5. But in my statement of claim, which is the pleading, this is the statement of claim that accompanies the rates. In the statement of claim, in my reliefs, I have just relief 1 and 2. So this interest one is not there. So I only have recovery of the sum and damages. Now, because I have not brought the interest over here, and I've also not brought the special damages, the court will say that on the authority of entry and amponsa, I'll be deemed to have abandoned that particular relief. On the authority of Unilever Ghana Limited versus Karma Health Services, I'll be deemed to have abandoned those reliefs, because reliefs mentioned in the rates that are not repeated in the statement of claim, they'll be deemed to have been abandoned. In the same way, if you mention reliefs on the rates, but you vary them, you are told that what? They'll be deemed to have, the reliefs you are seeking will be deemed to have varied to the extent of what you have put in your statement of claim. So the reliefs you put in your statement of claim, they are very important. And they can finish your case, because if you have not repeated a relief over there, then it means that you'll be deemed to have abandoned it. And when the court is giving its final judgments, do not grant you any remedy on that particular relief. So that is why we've been told under Order 11 Rule 15.1. And whenever I mention the orders, make sure you have opened the CI 47 to see it for yourself. Under Order 11 Rule 15.1 of the CI 47, we are told that a statement of claim shall specifically state the relief or remedy which the plaintiff claims, but costs need not be specifically claimed. Again, let's look at this case of Hydrofoam Estates Ghana Limited versus Owusu. Hydrofoam Estates Ghana Limited versus Owusu, reported in 2013-2014, Supreme Court of Ghana Law Report at page 1117. And I'm referring to this case because of Order 11 Rule 15.1 that says that every statement of claim shall specifically state the relief or remedy that the plaintiff claims. The only exception is for costs. If you don't specifically claim costs, that one, the cost will still give it to you. But any substantive relief you want, that one, you must claim it. And Order 11 Rule 15.1. Now, let us see what the court said in this case of Hydrofoam Estates Ghana Limited versus Owusu, reported in 2013-2014, Supreme Court of Ghana Law Report at page 1117. And I read as follows. I'm reading from the case. By the writ of summons sealed on 7th October 2008, the plaintiffs claimed against the defendant only one relief as follows. Perpetual injunction restraining the defendant's company, its agents, assigns, servants, privets, and workmen, or otherwise, howsoever be from interfering with the plaintiff's peaceful and quiet enjoyment and possession of their land. It must be pointed out that the endorsement was not for any substantive relief known in law. No objection was taken by the defendant on the recent authority of Roxon versus Julius Shipping Company SA versus Voltex, which affirmed this court's previous decision in Republic versus High Court Tenor, ex parte owners of MV Esso Spirits, that such a claim is void in law. In this case, however, upon reading the writs together with the accompanying statement of claim, the defect in the writs was cured by the statement of claim filed together with the writs. This is the current position of the law as ably expounded by our worthy brother, Badegbe GSE, in the more recent case of Opoku No. 2 versus Access Company Limited, in which our able brother said at page 1222 as follows, and I quote, "The writ of summons ought to be read together with the statement of claim in order to determine if there was any cause of action before the courts. This is so because a statement of claim may, in appropriate cases, as provided for in Rule 15.2 of the CI 47, amplify or diminish the scope of the writ on which it is founded. The defect on the writ, which was in our view, cured by the accompanying statement of claim, which was filed together with the writ. The cause of action of the plaintiffs was amply pleaded in the statement of claim. Now, what do we get from this so far? That there was a defect in the way the writ of summons, the reliefs that were endorsed on the writ of summons. But the court is telling us in this case of Hydrofoam Estates Ghana Limited versus Owusu, that the defect in the writ, it was cured by the accompanying statement of claim. So you can see that a lot of emphasis is being given to the statement of claim. So we saw in the case of Unilever Ghana Limited versus Karma Health Service Limited, that if you have some reliefs in the writs, which you have modified in the statement of claim, the relief that you have modified in the statement of claim, they will take precedence over the one in the writ of summons. We've seen in the case of Entry and Amponsa, reported in 1964, Ghana Law Reports, page 531, per Hayford Benjamin, that where a claim is contained in the writ of summons and it is not repeated in the statement of claim, the plaintiff will be deemed to have abandoned that claim. It means that the one that takes precedence is the statement of claim. And we've seen in Hydrofoam Estates Ghana Limited versus Owusu, that where there was a defect in the relief, that the writ of summons itself didn't have any substantive relief. But the court noted that if they read the statement of claim, the defect contained in the writ, it was cured by what was in the statement of claim. So the cause of action was properly before the courts. This will bring us to the end of our first part of the discussion we have on commencement of actions. Commencement of actions. Commencement of civil actions. And you see, the reason this is important is that, as we have seen already, we have mentioned that there are three principal means of commencing a civil action. You'll recall that we mentioned that what we said in this lecture, that the principal means of commencing a civil action, they are writ of summons, petition, and originating notice of motion. We mentioned that under Order 2, you have been told that subject to any existing enactment to the contrary, all civil proceedings shall be commenced by filing a writ of summons. But there are other modes of commencing a civil action. They are writ of summons, petition, and an originating notice of motion. I asked the question at the beginning, what is the consequence of commencing a civil action with the wrong means? Would it be a mere irregularity that can be cured by Order 81, or it will go to the root of the matter and go to jurisdiction? And we mentioned the case of Ahinakwa II. Ahinakwa II. Substituted by Ayikain Okainja III and others. Reported in 2011, one Supreme Court of Ghana Law Report at page 205. Badegbe GSA mentioned that if you fail to commence the action through the proper means, then it will be serious that it will go to jurisdiction so that it cannot be cured by Order 81. So if you are supposed to commence an action by a writ and you go by a petition, that will be a defect that will go to jurisdiction, and then the whole action can be struck out for want of jurisdiction because you have not properly invoked the court's jurisdiction. Then I ask the question, what if a statute has provided for a remedy, but the statute has not provided the means of commencing the action? Remember that the statute has provided for a remedy, but hasn't given you the means of commencing the action. Remember, I refer to the dictum of Francis Obridje, as it then was in Fidelity Bank. Fidelity Bank, you remember that case? That was to the effect that where a statute, that's the Fidelity Bank Ghana Limited versus Gideon Ayiku, that where a statute provides for a remedy, but does not provide the means by which the remedy will be attained, the party may approach the court for any of the known means. And remember, in this case, it was something under the Borrowers and Lenders Act that had been repealed. The statute had a particular remedy, but it hadn't specified how the jurisdiction of the court should be invoked, whether by a writ, whether by an application, whether by a petition. It only had a remedy without specifying how we should invoke it. And we're told that in such instances, a party could approach the court by any of the known means. And in that case of Fidelity Bank Ghana Limited, the party approached the court through an originating notice of motion, and the court held it to be proper. And the court relied on the case of Republic versus Central Regional House of Chiefs and others, as per the Jan the 9th under the 10th interested party. And then I asked the question, what categories of actions are commenced by an originating notice of motion? Like, we should give examples. Remember, I gave you an example that if you are going to commence an action for the enforcement of fundamental human rights, because as Article 33 says, you may apply to the court for redress. You can go and enforce human rights provisions by an originating notice of motion. Remember what an originating notice of motion is. When a statute mentions that you shall apply to the court for a remedy, but doesn't tell you how you should apply, you can go by an originating notice of motion. Another example we look at was an application for judicial review pursuant to Order 55 of the CI 47. Again, we also look at an application for an order of committal and Order 50 of the CI 47. Then I asked the question, what are categories of actions that you can commence by petition? I gave examples: matrimonial causes under Order 65 of the CI 47 and Section 11 of the Matrimonial Causes Acts. I gave another example: parliamentary election petitions commenced pursuant to Article 99 of the Constitution, as well as Section 16 and 17 of the Representation of the People Law of 1992, PNDS Law 284. I gave another example: presidential election petitions in the Supreme Court pursuant to Article 64, the 1992 Constitution. And I gave another example: winding up of a company or liquidation of a company under the provisions of the Corporate Insolvency and Restructuring Act of 2020, Act 1015. That's one too, you can go by a petition. Then we look at the writ of summons. For writ of summons, we explain what it was. That is a command commanding you, the defendants, to enter appearance in the name of the Republic. That in the name of the Republic, we are commanding you. We mentioned that it is sealed by the registrar, and they will see the stamp of the Chief Justice over there. We look at the content of the writ of summons, and over there, as we look at the writs, we saw that we must have the residential and occupational address of the plaintiff, residential and occupational address of the defendants. Then the reliefs the plaintiff is seeking, it must be on the writs. If you are suing by a lawyer too, we said that you must have the occupational address of the lawyer. We saw all those ones over there. Then I mentioned a critical factor under Order 206, that every writ, when it is being filed, it shall be filed together with the statement of claim under Order 11. And no writ is supposed to be issued unless it is accompanied by a statement of claim. And I mentioned under Order 11 Rule 1, that if a person files a writ of summons, and it doesn't have a statement of claim, the defendants can apply to the court for the whole action to the dismiss. And then finally, we asked ourselves that if a person commences an action, states some reliefs on the writ of summons, but those reliefs are not stated in the statement of claim, what is the implication? We mentioned that if you state the reliefs on the writ of summons, and then you don't repeat them in the statement of claim, you begin to abandon those particular reliefs. And we supported ourselves with the case of Unilever Ghana Limited versus Kama Health Services, and also the case of Entry and Amponsan. And then we finally wrapped up with the case of Hydroform Estates Ghana Limited versus Owusu, reported in 2013-2014, Supreme Court of Ghana Law Report at page 1117. This will be the end of our first part of our discussion on commencement of civil actions. Thank you.